Welcome everyone, and thank you for joining. We'll get started in just a few moments. We'll probably be starting about 1:01 to give people a bit of time to get logged in. Jeremy, how are you doing this afternoon?
I'm good.
Yeah,
I'm doing very well. Thanks.
great.
Yourself?
I'm doing really well, thank you. I'm enjoying this kind of blustery day. You know, we don't have many left, so.
Yeah, that's right. We're approaching the 4th of July weekend, which is typically when things start to turn. Although I will say that it's been pretty nice the last week or so.
That's true. It really has been. My jalapeno plants have been taking off. So
Nice.
Yeah, very excited about that.
You've been spending a lot of time out in your garden?
Well, so our yard is just that typical Salem clay mud. So I have like little hangers that go over the side of my balcony or my deck. And so I made myself a little herb garden and put some jalapeno plants in. Yeah. All right. So everyone, welcome. Thanks so much for joining us today. We're going to be discussing changes coming to the eviction moratoria, and this webinar is being presented concurrently in Zoom and in YouTube. If you have a question for any of the presenters, in Zoom, you'll use the chat function and you'll select all presenters. If you select all panelists, I'm sorry. If you select all panelists and attendees, then your question goes to everyone in the group. So we recommend using the all panelists function. If you are in YouTube, you can just use the chat function and we will be routing those directly back into the panelist chat. So if you have any problems for support, you can email info@oregonrealtors.org, or you can call either of those numbers on the screen. If you are which are the office numbers for OAR. If you registered for this course, then we're automatically processing your CE now, so you don't have to do anything to get CE for being here. So thank you for joining us. And with that, I'm going to introduce our host today, Jeremy Rogers, who's the Director of Legal Affairs and Public Policy here at OAR. So Jeremy, welcome and thank you, and go ahead and take it over.
All right, great. Thank you so much, Erica. This is a great opportunity in a timely fashion to get information out to the OAR members about new laws that just passed. So I'm going to share my screen, walk through a presentation about the new eviction law, and then we're going to try to spend most of the time today answering questions, because I know that there'll be quite a few. So let me share my screen and get into it. All right. So as most of you all know, the state of Oregon has a new eviction law. The legislature met last week for 3 days in a special session, and they statutorily passed laws relating to residential and commercial evictions. Previously, we had been living under a governor's executive order related to evictions, as well as federal laws around evictions from the CARES Act, which are still in place, as well as some local eviction bans. But this was the first time that the legislature had weighed in. Now, before I get into the details, I just want to make clear that this is a summary of recently passed legislation. It is not legal advice. Legal advice requires specific facts and circumstances, and applying those to the law. Here, we're just giving an overview of the law, and we're going to answer general questions about the law. But we're not providing legal advice to any particular factual situation, because we simply cannot get into that level of detail with anyone on the call. Also, as you know, that COVID-19 related eviction and other COVID-19 related executive orders, laws, and issues are changing rapidly. Hopefully this one will be a little bit more steady. I mean, now that the legislature has passed this, I would expect there'll be fewer changes coming as a result of executive order, but it's always possible. And it's really the responsibility of landlords and tenants to keep up with the law. And this presentation may quickly become out of date. So let's talk about what is in the law. House Bill 4213. I have received word that the governor has signed the legislation, so it is in effect. And the legislature passed it on Friday, June 26th. The bill deals with both residential and commercial evictions, and it bans certain notices and evictions during an emergency period, which is defined as April 1st through September 30th. It also creates a 6-month grace period. This is new. This was something that folks in Multnomah County already had in place, but it's new statewide. A 6-month grace period after the emergency period ends, so beginning on October 1st, 2020, that lasts until March 31st, 2021. And during that grace period, landlords are not able to evict tenants for unpaid balances that accrued during the emergency period. The penalties for landlords for violations of any portion of the law are steep. Tenants can sue for injunctive relief and get possession of the unit if they were wrongfully evicted, as well as actual damages and 3 months rent for landlord violations. And this is different than the governor's order. The governor's order was a Class C misdemeanor criminal penalty. I'm not aware of whether that penalty was ever issued to any landlord across the state during the period of the governor's moratorium, but these civil penalties are more typical of landlord-tenant law, although with even more relief for tenants related to injunctive relief and possession. And so it's much more likely that these penalties will be implemented if there are violations by a landlord. So the risks are steep. And the law is repealed in its entirety March 31st, 2021, which is the end of the grace period. So today we're going to talk about, in the residential eviction category, we're going to talk about non-payment and notices and evictions for non-payment. We're also going to talk about no-cause terminations. We're going to talk about qualifying landlord reason terminations. These are the statutory reasons that were implemented with Senate Bill 608 last year, in which a landlord previously was able to terminate a tenancy after the first year. So we'll talk about how this new law impacts those Senate Bill 608 reasons. And then tenant cause terminations, those terminations that are a result of tenant violations. So first, with respect to non-payment, so in the legislation, non-payment means rent, non-payment of rent, late charges, utility or service charges, or really any other charge or fee that comes due during that period of April 1st through September 30th. And landlords cannot issue notices or related to termination or pursue evictions for non-payment of those rents and fees and charges that accrue between April 1st and September 30th. And they can also not evict tenants during the grace period that extends until March 31st, 2021 for non-payment that occurred during that emergency period of April 1st through September 30th, or April 1st, through September 30th. So we'll get into more details about, what if the tenant had a non-payment balance from before April 1st or has a non-payment balance after September 30th. In those instances, a landlord would be able to issue a notice or pursue eviction, but we'll talk more about those later. The landlord cannot charge late fees or assess other penalties for any non-payment that accrues between April 1st and September 30th. Landlord cannot report non-payment that accrues between April 1st and September 30th to a consumer credit reporting agency, and the landlord cannot otherwise interfere with the tenant's possession of the property based on any non-payment that accrues between April 1st and September 30th. There are a couple types of notices that are allowed as it relates to a tenant's non-payment between April 1st and September 30th. So during that emergency period of April 1st to September 30th, a landlord can send a notice to a tenant letting them know that they still owe the rent, as long as that notice also states that no eviction for non-payment of that rent is allowed until after September 30th. So you can tell your tenant, hey, I know that there's this eviction moratorium going on, and you may not think that you owe me the rent, but you do owe me the rent, but I cannot pursue eviction until after September 30th. It's not clear what that notice would accomplish, other than letting the tenant know that this is not a rent forgiveness, but it's just a temporary moratorium, which is important because there may be confusion out there about that among tenants. The second type of notice that is allowed is a notice after the emergency period. And this notice is to let tenant know that they still owe you the rent. You can ask them to inform you of their intent to take advantage of the grace period for rents that came due April 1st to September 30th. So that's the grace period that lasts an additional 6 months until March 31st. You can ask the tenant to let you know if they intend to use that. And you can inform the tenant that they can be evicted for non-payment of rent that comes due after September 30th. There are several other very specific requirements of what needs to be in this type of a notice. The document that we posted on the OAR website and sent out via email yesterday lists those requirements in much more detail. And it also links to the bill where those requirements are listed. I also think that I know that Multifamily Northwest and other landlord groups are likely to create forms based on this. And if not, OAR will be able to create something that you could use or at least copy from as well. It's very important that these notices follow the statutory requirements. That first notice during the emergency period needs to say that the tenant cannot be evicted for non-payment of rent that came due during the emergency period until after September 30th. It has to include that statement. And this post-emergency notice has, as I mentioned, many components that have to be a part of it. So you need to take a look at those other documents to make sure that you're preparing that notice correctly. So let's talk a little bit more about the grace period. The grace period runs October 1st, 2020 through March 31st, 2021. The grace period does take effect automatically. However, as I mentioned on the previous slide, if, but only if, a landlord sends a post-emergency period notice, as we discussed on the previous slide, and it meets all the statutory requirements that required for that notice, then the tenant is required to give actual notice to the landlord of the tenant's intent to use the grace period. So in that letter, the landlord can say, I want you to let me know if you intend to use the grace period by a certain date. And that date has to be at least 14 days past when the landlord sends the letter. But if the landlord does that and otherwise provides the lawful notice, then the tenant is required to tell the landlord by that date that they do intend to use the grace period. However, the tenant's failure to give notice to the landlord that they intend to use the grace period does not prevent the tenant from using the grace period. But what it does do is it creates a penalty, and the landlord is able to recover damages equal to 50% of 1 month's rent following the grace period if the tenant took advantage of the grace period without providing the landlord notice pursuant to the landlord's earlier notice to the tenant. And then also in the notice that a landlord sends to the tenant post-emergency period, the landlord may offer an alternate voluntary payment plan. So this would be some type of payment plan that is more particular than simply you've got a 6-month grace period and you need to pay me the money by the end of the grace period. So this would be some more detailed installment plan. And but if the landlord does that, they do need to state that the alternate payment plan is voluntary. The bill also has a specific order of application of payments that landlords must follow. So if a tenant is behind on rent, the landlord must apply payments that the landlord does receive in the following order. First, it has to go to rent for the current rental period, then to utility or service charges, then to late rent payment charges, and then to any other fees or charges owed by the tenant for tenant violations or other tenant-related issues that have come up currently or in the past. So this is very different than the current law. Under current law, typically the payment first goes to any late rent payments. So that's a significant change, and it really will require landlords to keep a very precise itemized ledger of payments, because this is an area that a landlord could easily screw up. And even if a landlord believed it had a right to terminate the tenancy because, let's say, non-payment occurred prior to April 1st, or non-payment occurs for rent that came due after September 30th, and in those instances, the landlord still has a right to terminate. The question is going to be whether the landlord accurately applied all payments and can show that to the court to really prove which rent was paid and which rent was not paid. So let's talk some more about before and after the emergency. Landlords may issue notices and pursue evictions for non-payment that accrued prior to April 1st or that accrues after September 30th. Though a tenant that doesn't pay their rent prior to April 1st or after September 30th was not protected or will not be protected by this emergency period. However, as we mentioned before, the trick is going to be following that statutorily required application of payments and making sure that it's in correct order, because the risks will be very costly for making mistakes. Now, another thing to keep in mind, and we'll touch on this later on in the presentation, is that even though this new state law would allow you to issue notice or pursue eviction for rents that came due prior to April 1st or after September 30th, there's still the federal CARES Act eviction ban, which overlaps with this a bit, and we'll talk about that later. And there are still local government bans, most of which have been subsumed by the state law, but that isn't true in all cases, and we'll talk more about that later. So I want to move on now from non-payment issues and talk about other types of terminations that the law addresses. So let's talk about no-cause terminations. So under current law, a landlord can issue a 30-day no-cause notice during the first year of a month-to-month tenancy. That doesn't have to be a reason. 30-day notice can terminate the tenancy in the first year for a month-to-month. Under this law, you cannot do that. And that prohibition lasts through the emergency period. So you cannot do the 30-day no cause through September 30th. Starting October 1, you would be able to do the 30-day no cause. Under current law, you can do a 30-day no cause non-renewal of a fixed term tenancy. If you recall, prior to Senate Bill 608, a fixed term tenancy, ended when the term ended of the tenants of the fixed term. But with 608, there's notice requirements related to the first year, and then prohibitions if it's after the first year. Well, under current law, you can do a 30-day no-cause non-renewal notice to say that the fixed term lease is ending and the tenant must vacate and the lease is not going to be renewed. Under this law that's just passed, you cannot do that. Under current law, and I keep saying current law, what I really mean is under law as of 2 or 3 days ago. But under law as it existed before this new bill passed, there was also some special rules related to when a landlord lives in the same building or unit or duplex with the tenant, related to the landlord's ability to issue no-cause notices. Those are also not allowed under the new law that has passed. However, the legislature did throw one bone to landlords related to no-cause evictions. If the 1-year mark passed during the emergency period, so if your tenancy crosses 1 year during this period where you're prohibited from issuing a no-cause notice, you will get a 30-day window at the end of the emergency period. So starting October 1, to issue a no-cause eviction. If your tenancy was still within the first year at the point of October 1st and it hadn't crossed the 1-year threshold yet, you would still you would have the right to issue the no-cause because you'd still be within the first year. But because no causes are only allowed within the first year, this provision that the legislature added was to preserve the right of a landlord who otherwise could have given a no-cause eviction but was prohibited, and during the emergency period crossed the 1-year mark and lost that right. They are given that right for a 30-day window at the end of the emergency period. Now let's talk about qualified landlord reasons for termination. So these were the reasons that were established in Senate Bill 608, the 4 reasons that a landlord could terminate a tenancy after the first year. Because if you recall, Senate Bill 608 essentially banned no-cause terminations after the first year. And so they created several reasons that would still allow for a landlord to terminate a tenancy for a reason other than a tenant violation. One of those reasons was demolition of the dwelling unit. So this is after the first year and with a 90-day notice. Prior to the passage of the bill we're talking about today, you could deliver that notice after the first year, 90-day, for demolition of a dwelling unit. Under this law, you cannot issue that notice. Prior to this law passing, you could issue a 90-day notice after the first year if you're going to substantially remodel the unit and it would be unfit for occupancy. Under this law, you cannot issue that notice. Prior to the passage of this law, you could issue a notice 90-day after the first year if the landlord or a family member was moving into the unit. Under this law, you cannot issue that notice. Also, prior to passage of this law, and probably the one that's most important to all of you, is that if you sell a home to a person moving in as their primary residence, you could issue a 90-day notice after the first year of tenancy. The legislature did preserve this right in this bill. This is the one landlord cause that's allowed. And the reason that it's preserved is because of the work of OAR's government affairs team that advocated for this. And Sean Gillian's our lobbyist who was working this in the building, fought very hard to make sure that this was included in the bill. And if you recall, just from the law as it exists today, if you're going to issue one of those 90-day notices for the sale of a home to a person moving in as a primary residence, it's got to be 90-day notice. It's got to specify the reason for the termination. Got to provide proof of the offer. If the landlord owns more than 4 dwelling units, they have to pay 1 month's rent with that notice. And the notice must be given within 120 days of accepting the offer. That last part is typically not a problem or an issue, but it is part of the law. Now, let's talk a bit about tenant cause terminations. I'm not going to get into all of these other than to say all of the existing statutory tenant cause reasons to terminate are still available to landlords. So material violations of the rental agreement, violence, damage to property, drug and alcohol violations, unpermitted pets, the 3 strikes rule that was created as part of Senate Bill 608 that also gives the landlord the opportunity to not renew a lease if there was 3 violations and notice was provided to the tenant. So there has been no changes to the tenant cause issues. These are all still available to the landlord. We're not going to get into the details of all of those, but of course, if you're going to pursue one of those, you must follow all of the statutory requirements that have always been related to those types of terminations. Other provisions of the legislation. Currently, there's a 1-year statute of limitations in the law related to bringing a landlord-tenant action. This bill tolls that, so essentially pauses that statute, so it's not, days are not accruing against that statute of limitations during this emergency period and grace period. So the days between April 1st and March 31st of 2021, April 1st, 2020, March 31st, 2021 will not be counting against that statute of limitations. And under current law, if a landlord accepts partial rent payments, then in some cases they waive their right to terminate. This statute, this new law, makes it clear that acceptance of partial rent payment is not a waiver of a right to terminate. We're not going to get into the details much today on commercial tenancies. We posted something online related to commercial tenancies. The law is largely the same, very, very similar to the residential tenancies law. But of course, the commercial tenancy law really just focuses it on the non-payment. And of course, it doesn't really get into all these other residential tenancy issues around no cause and landlord-based reasons and all of that. So it's really focused on non-payment. It does not have a provision related to the order of payments required. We talked about that related to residential tenancies, a very particular order that you have to apply payments that you do receive if your tenant is late on rent. That's not included in the commercial eviction moratorium. There's no tolling of the statute of limitations, and that's largely because under the commercial, if you have a dispute with your tenant under a commercial lease, you're largely going to be pursuing that under contract violations that don't have a 1-year statute of limitations to begin with. They have a longer statute of limitations. And as I mentioned, we put together a guide on the website. There's a link to that in the chat box, and that has more information on both the residential and commercial. Now, secondary question is whether courts are even processing evictions. Sort of separately from what the law allows, are the courts open for business related to evictions? It's really the Oregon Chief Justice of the Supreme Court that is setting those procedures. She's been issuing updates to her orders every month or so. The last one was May 15th. In that order, she said that eviction proceedings can begin on July 1, but only in counties where at least 50 people are able to congregate. That would only include counties that are in phase 2. She does give some discretion to local presiding judges, including if the local presiding judge wants to allow certain proceedings to happen remotely. But you really will need to check the latest orders from the Chief Justice, which I suspect would be updated soon, as well as with the clerk of your local county court to understand their particular procedures. In the guide that we link to in the chat box, there is a link to the page where you can find the latest Chief Justice orders. Now, everyone's so caught up with this state law that I think a lot of people have forgotten that there's also a federal eviction moratorium in place. This eviction moratorium only applies to properties that are really touched by the federal government, either through a federally backed mortgage or that are receiving federal subsidies of some sort. That eviction ban prevented evictions for non-payment of rent or other charges for 120 days after March 27th. That is a typo, and I apologize in this slide. That is meant to say July 25th. So when I count 120 days from March 27th, I get July 25th. You should do your own counting if you're intending to utilize, to do an eviction after that date. And a landlord also cannot charge fees, penalties, or other related charges for non-payment during that period. And then once the 120 days is up, if a landlord does issue a notice of eviction, it has to be at least a 30-day notice. Now, the text of the CARES Act does not specify that it only applies to rent that came due after the passage of the act. So the CARES Act doesn't have this quote unquote emergency period in which we're really focused on related to whether we can or cannot evict for non-payment during that period. The federal CARES Act just says you can't evict for non-payment. So I think conservatively, we have to interpret that to mean that it doesn't really matter when the non-payment happened. You can't evict for non-payment. So even under the state law now, you could pursue an eviction for rent that had come due prior to April 1st. Under this CARES Act, I don't think that you can. Now, I don't know if that's been tested in court, but the way that it reads would suggest that it's for any non-payment. So you still would have to wait until after July 25th, and then do the 30-day notice if you had a federally backed or subsidized mortgage and you were intending to evict for a non-payment that happened prior to April 1st. There's also local ordinances in place and local orders. Most of those have been subsumed by state law, but it's important to check with your county and city because they may be updating things. In particular, I want to point out that in Multnomah County, the Multnomah County residential eviction moratorium was updated to align with the governor's eviction ban, but it stated that it's in effect until the governor's order is lifted or the county's emergency declaration ends, whichever is later. And so in Multnomah County, they have a moratorium that I believe would still be in effect even after the governor's order ends today, which is the last day of the governor's order, because their emergency declaration, I believe, is still in place. Now, given what the legislature passed, most of the evictions that would be prevented under the county order are already now prevented under the state order, but there may be some differences. And so you have to pay attention to that Multnomah County order. And I put a link in there to where you can find more information on that order. The Multnomah County order also has a 6-month grace period, but now the state law has a 6-month grace period. I've not had time yet to compare those grace periods. I assume that they're substantially the same, and it's likely that the state grace period will control here, but I think it'll be important to compare those two to make sure that there aren't additional provisions in the Multnomah County order that would require compliance, and there may be. So that is the end of my presentation, and we're going to move to Q&A. It looks like we got a lot, which is great. On the screen is my email address. Please do email me with any additional questions. And as I mentioned, we've put in a lot of materials on our website. There's links there to the guides that we put together, including on this eviction ban, as well as to the page where we put timely updates related to these types of issues. With that, I'm going to stop sharing my screen and go to the questions. All right. Now, I will say before we hit these questions, as I mentioned, we're not going to be providing legal advice today, so we're going to be answering questions generally, not related to the detailed specifics of your circumstance. And also, this is a brand new law. Lawyers are reading it, interpreting it. There's going to be some differences of opinion. There's going to be some revelations that come to light as more people study it. And so just keep in mind that this is all very new. Okay, so let's see. How does the new law affect eviction of a previous owner after a trustee sale? That's a really good question. I believe that this is something that eviction that is allowed and included in the types of evictions that are still allowed related to tenant cause. I know this isn't always related to tenant cause, but when you read the statute, I believe that this situation is covered in something that can still, an eviction that can still occur. However, what would be great is an opportunity to just look into that a little bit more and get back to you on that. And so it's like I don't know who's typing the questions, but we can add that. We can, if there's answers to questions here that we want to look into a little bit more, we'll add those answers to the documents that we put on the website, and so you can see answers to those questions there. So I think that type of eviction would still be allowed, but I want to look into that a little bit more. Can we print this presentation? Yes, we'll send the presentation around afterwards. I'll clean up that typo that I made. Yeah.
And we will also, this is a recorded training, and so we'll host it on YouTube for as long as it is still accurate.
Is the payment due in full for all past rents after September 30th? So I'm not, let me take a stab. I'm not sure I entirely understand what the question means, but let me just walk through the different pieces and hopefully we'll answer it. So if rent was accrued prior to April 1, so the March rent, okay, or after September 30th, so say the October rent, those rents are due in full. And you can pursue notices and evictions if those rents are not paid in full under the rights that you have always had under the law. You still have to follow, the appropriate notice process and all of the other statutory requirements, but that is allowed. And so yes, in those situations, a full rent is due. During the emergency period, that period between April 1st and September 30th, any rents that came due then, they're due in full, but not until after the grace period ends on March 31st. So nothing in this law lets tenants permanently off the hook for paying you the full amount of rent. And nothing in this law even really prevents you from pursuing the money damages against the tenant to get paid that, but it does prevent you from evicting a tenant or issuing notices of eviction based on that. And so while the tenant owes you the money, in reality, they don't really have to pay it to you until after March 31st, or until March 31st, if that was rent that came due between April 1st and September 30th. So maybe the person who asked that question can chime in and let me know if I answered it, and if not, we'll come back to it. Next question, if a landlord has a property manager and the property manager does not follow the law correctly, is the property manager, landlord, or both liable for the penalties? That's a great question that I think has a pretty definitive answer under existing landlord-tenant law. It doesn't change under the current law. I believe that the answer is that both are liable. However, I'm going to check with some folks who do landlord-tenant law on a regular basis just to confirm how that works, but nothing in this statute that I see changes that. So it would be the same as it is under current law. but I will confirm on that one, and we'll also add that to the document. Question, can you restate that about the 30-day window? Connection was buggy. Yeah, so this is if you're in the first year of a tenancy with the tenant and it crosses over the 1 year mark during the emergency period, so between April 1st and September 30th, that means that you would have permanently lost your right to issue a no-cause eviction, because you can only issue a no-cause eviction in the first year, but this law says you can't issue a no-cause eviction between April 1 and September 30. So if after September 30th you were already past 1 year, your tenancy, you would have been out of luck and not able to issue a no-cause. So what the legislature did in this situation to remedy that is they gave landlords essentially a 30-day window at the end of the emergency period. So emergency period ends September 30th, and then you really have the month of October to issue a no cause, even if your tenancy has crossed over past 1 year. So hopefully that makes sense. Now, if the tenancy was already past 1 year prior to the emergency period, you would not be able to use this right, because you would have not had the right to begin with to issue the no cause. Okay, next question. Under the qualified landlord reason for termination, what are the rules for a seller intending to sell with no intention to occupy the property? So when Senate Bill 608 passed, it created a limited set. This was last year, 2019. It created a limited set of reasons for which a landlord could terminate a tenancy after the first year. Selling the property to someone who does not intend to occupy it as a primary residence is not one of those reasons. There's only 4 reasons. One is selling it to a person who intends to occupy as a primary residence. Another is if you're going to demolish it or convert it to a use other than a residential unit. Another is if a family member, immediate family member, or yourself as landlord are going to move in. And another is if you're going to substantially remodel it to the point where it is uninhabitable. So unless one of those things are true, you don't have a landlord reason to terminate, and you can't terminate. And that's not the function of this law, that's the function of Senate Bill 608. Now, if you sell the property to a person who is then going to substantially remodel it, then that person would be the landlord at the time, and they would then have a qualifying landlord reason. Or if that person was going to demolish it, or if that person was going to convert it to non-residential use, or if that person was ultimately going to move in or have their family member move in, then at that point, they would have a landlord reason, and they could issue the 90-day notice. All right, next question. So I'm hearing that we have to send out a letter explaining the grace period and asking them if they intend to utilize this grace period in order to have these protections as a landlord. Yeah, so this whole letter thing is kind of funny, because the way the law is written, tenant gets to use the grace period no matter what. So even if you don't send a letter, or even if you do send a letter, the tenant can use the grace period. The question is whether or not the tenant is going to be forced to tell you their intent to use the grace period and pay you damages if they don't. And that's one reason why this letter comes in. So I would strongly encourage landlords to send this letter once the emergency period ends. As I mentioned, there's very specific things that need to be in the letter that's posted on our guide. And in that letter, you want to tell folks that they still owe you the rent due during the emergency period. You know, that this was not a rent forgiveness. It's just, you know, they still owe it to you ultimately, that there is a grace period, but that they need to tell you that they want to use it by a particular date. And, you know, letting them know that if they don't pay their current rent, then they can be evicted for that because the emergency period's over. And there are several other things that you include in that letter. So it's a good letter to send. It puts the tenant on notice of this whole situation so that they understand it. I think in particular, it really is helpful for letting them know that if they don't pay rent that comes due after September 30th, they can be evicted. Tenants could be very confused by this whole grace period issue and think that the true rent moratorium lasts all the way to March 31st, even though really what's happening is that the rent moratorium is April 1st to September 30th, and then there's a grace period to pay that back. But any other rents that come due after September 30th can result in eviction. So letting the tenant know all these things will definitely position the landlord to be in a better spot. They don't have to send that letter, but I don't understand why a landlord would not send that letter. And then, of course, if the landlord, if the tenant does not notify the landlord of their desire to use the grace period, the landlord could get damages worth 50% of 1 month's rent. It's unclear from the statute whether that's an assessment that the landlord can just make immediately. You know, if the landlord doesn't, or if a tenant doesn't get back to them by the date that the landlord specified to let them know if they're using the grace period, can the landlord just tack on that 50% of 1 month's rent fee, or do they have to go to court to pursue that? That's unclear. In the statute, it's framed as, that the landlord can pursue damages. So, they may have to end up going to court to ask for that, but that's something that will become clearer as this unfolds. Next question. If a tenant does damage to a property, are we allowed to send them a bill during this emergency period if we include the language regarding no eviction for non-payment until after 9/30? And what about billing for monthly utility charges? Is that allowed? So let me take the second one first. Billing for anything is allowed. I mean, you're going to be, you're going to be charging them rent, and if they are being billed for utility fees, then they can receive the bill for the utility fees. What you can't do is send a notice of termination related to the non-payment of those utility fees. So I think that covers the utility question. The damage, tenant damage question. So this is not related to non-payment of rent. And so, yeah, the landlord would be able to send them a bill during the emergency period related to the damages that the tenant has done. Then there, though, would be a secondary question related to whether the landlord could evict the tenant for not paying that, and related to in what order of payment, when the tenant does provide payment, in what order should it be applied. I believe in the list that I provided earlier that type of payment from a tenant is at the bottom of the list. So if you did charge them for damage and then they sent you in a payment and they were behind on rent, you'd have to apply that payment first to all the other things, the current rent, the utilities, the past due rent, and then you could apply it to this charge for damages. All right. Next question. If we do not send a letter to this effect, we do not have the protection. Am I tracking correctly? The only the protection that the letter provides is the ability to collect 50% of 1 month's rent if the tenant does not notify the landlord by a specified date that they intend to use the grace period. Otherwise, I don't think there's really any protections that it provides per se, but I think it provides protection in general because it's very important for the tenant to understand what the situation is. And the tenant's not going to understand all of this stuff about emergency period, grace period, the difference between rent that came due between April 1st and September 30th and the difference afterwards. And so putting the tenant on notice of all of that, I think is going to be really important for you to be able to proceed over that grace period with a common understanding with the tenant of what they owe you. But the only thing per se that the notice gives you is the ability to collect that 50% rent damages if they don't notify you related to the grace period. Can rents still be raised? Yes, so this bill does not address rent raising. Rents could still be raised according to current law and the limitations of Senate Bill 608. Next question. If the governor forbid eviction, we shall unite to ask property tax reduction. Okay, so that's just a policy recommendation for the government affairs team. Note taken. Are you able to send out or post this presentation? Yes. Next question. I missed the first few minutes. Can we get a recording of the slides? Yes. Next question. A little more info about listing and selling, buyers wanting the tenants out and how that might work. Yeah, this is a great question and really important for all of you realtors. You know, the OREF forms were never really updated after 608 passed, with all of these new restrictions around notices and terminations from 2019. And so this has kind of been a thorny issue, generally speaking, since Senate Bill 608 passed in 2019, and then now even more so. So it's very important. My recommendation would be that any person who is selling or buying a property with a tenant consult with their own attorney to make sure they understand how all this works, and to make sure that they incorporate, if they want to incorporate a provision into their sale agreement that covers all of these issues and who's liable for what and who's responsible for what and who's responsible for issuing proper notice and who's responsible for paying a relocation fee if that's required and who's responsible for paying damages if there's a violation and all of that. I think now more than ever, it's critical to involve attorneys and have the buyer and the seller each have their own attorney helping them to navigate that situation. Of course, we'll be continuing OAR, we'll be continuing to put out information that can be helpful to all of you realtors to understand the overall structure of this situation and be aware of it and be aware of the need to let your sellers and buyers know that they should contact the attorney because of all these complications. But certainly realtors shouldn't be the ones getting into the weeds of all this landlord-tenant law, particularly with all of these revisions going on. They should be the ones telling their clients that, hey, there's a lot going on landlord-tenant law. There's Senate Bill 608 that passed last year. There's the eviction moratorium at the state level, some at the federal level. It's really important that you contact your own attorney and make sure that you understand what you're getting into, and that those attorneys can help in drafting up any language that the parties would want to include to allocate the benefits and the burdens related to the tenancy situation. Okay, reinstatement of landlord reason number 4 is not in any way tied to emergency and grace period. Came into immediate effect with passage of House Bill 4213. Yeah, so landlord reason 4 is allowed now, and it given the language of the statute, is allowed moving forward and was allowed in the past. The governor's order was unclear on this point of whether it prohibited termination for landlord reason number 4, the selling of the home to a person who intends to move in as a primary resident. It was unclear as to whether it prohibited that and other landlord-based terminations. A lot of lawyers thought that it did. Some lawyers thought that it didn't. But what the legislature has done here is crafted a law, and they've included in that law an emergency period that goes back to April 1st. And under the legislature's law, the landlord-based reason number 4 is allowed now. It's allowed during the emergency period. It's allowed after the emergency period. With respect to whether it was allowed under the governor's order, again, that was ambiguous. But I think that yeah, that was unclear. But under the law as it stands now, there was nothing wrong with landlord-based reason number 4 at any point during the emergency period or after the emergency period. Can you show a home sold with a 90-day notice to sell a home slide again? We're going to send out the slide, so I'll let that questioner take a look at that when we send them out.
Jeremy, I wanted to check in. We've still got quite a few questions to go through. Did you want to extend to 2:30 and keep going?
Yeah, we'll keep taking questions as long as they come in, as far as I'm concerned. So
okay, sounds good. So just to give everyone who's here to let you know, if you have to pop out, you can still type your question in the chat box and send it to all panelists, and we'll respond. And then you can always come back and watch the recording. That should get published in the next 2 days, and we'll share it out to everyone who's registered, as well as include it in our next newsletter.
Okay. How does the law affect a tenant-occupied duplex on month-to-month leases that the seller was supposed to give notice on September 16th to vacate due to demolition? Are they able to give notice on October 1st? Yes. They're able to give notice on October 1st, but they are not able to give notice prior to October 1st. Okay, if an eviction is in process and not related to non-payment of rent, can a listing and sale of the property proceed and have assurance the tenant will leave? So this is more related to the operations of the court than the law, because than the statutes. Nothing in the statutes prevents this eviction. If assuming it's a tenant cause. The question says if it's not related to non-payment of rent, and we mentioned earlier that there are several non-payment, several issues not related to non-payment that are still banned. You can't do a no cause, and you can't do a landlord-based cause except for the sale of a home to a primary resident. But presuming that the questioner is asking about a tenant cause, which is allowed to evict for. Then the real issue is just whether the courts are going to be processing that. And so it's difficult for me to answer that question, because I think some of that's going to be related to the particulars of your county and how quickly they're getting through the backlog of eviction related proceedings after July 1st, and whether your county is in phase 1 or 2. If the county's only in phase 1, then the governor or the chief justice orders don't allow eviction proceedings, other than, as I mentioned, there's some discretion given to county judges to do remote proceedings and other emergency-based things. But you really should need to check in, and what you probably would need to do is just, the question asks if there's an assurance, and there's never an assurance. And I would really look into what the procedures are in your county and what they're processing and what they're not, and how quickly they're getting through it. And then you'd want to base the structure of the sale agreement and the closing date and all of that. You'd need to factor in the realities on the ground of what's happening in the local court and how quickly they're processing those things. So that's not a satisfying answer. I apologize, but that's the best I can do on that one. Question, we mostly deal with sales, so how to navigate sales with tenants. Yeah, so again, this is really tricky. I mean, I think, as I mentioned, it's really important for realtors to be up to speed and understand the general framework of these laws and what's going on, you know, at a general level, so that they're aware, and they don't, you know, step into something that they're not at all aware of or familiar with. But it really is going to require attorneys, landlords, you know, buyers and sellers, working with their own attorneys and assisting in drafting language that will address the landlord-tenant issues and responsibilities, and ensuring that proper notice is given, and ensuring that the parties understand the limitations and potential fines, and you know, who's paying relocation fees if those are owed, and all of that. So I certainly, OAR will think about any additional tools that we can create to help our members think through and navigate these situations. But no matter what we come up with, certainly one of the top recommendations that we would come up with is to have both parties consult an attorney, their own attorney. I have a tenant who was behind on rent in March. Okay, she just paid 2 months rent. Formerly, the rule was that the oldest rent gets paid first, but now it is current rent, then backward. So can I evict them on March rent? So again, this is getting to a level of detail where, you know, I would encourage you to talk with your own attorney about this particular situation. What I can say generally is that prior to the law passing, a landlord was statutorily obligated to apply rent in the order that the existing statutes had demanded, and that order was oldest rent first. So until the governor signed this bill, and I don't know exactly when she signed it, I think it was today, but until then, you were actually required to apply it to oldest rent first. So you certainly were not doing anything wrong there. But now that it's passed, you have to flip that. And so if you're receiving that rent now, then you would have to apply it to the newest rent first. So I guess it would really depend upon when you took in that rent and when you applied that rent, and whether it was before or after the signing of this legislation. But again, as we get into the weeds on all of this, and particularly when you're very close to the time of when this law passed, and, you know, it's presuming a tenant's going to challenge you, you know, these are the types of things that are going to be, if a tenant does challenge, then these are the types of things that are going to be fought out in court. And so having a very detailed, precise ledger of payments and how you applied payments, and on what day you applied those payments, and consulting with your own attorney would certainly be well advised. Is there any way I can defend myself from so-called rent strikers? Can I have language in a letter to the effect of, if you can pay rent, you must pay rent, even if it's something I can't actually enforce? No, you can't do that. As I mentioned, the only notice you can really provide related to non-payment of rent or other fees is that you can, during the emergency period, you can provide a notice saying that the tenant still owes the rent. You know, the rent was not forgiven, it's still owed, but that the landlord cannot evict until after September 30th. That's really the only notice related to non-payment that you can provide during this emergency period. And then after the emergency period, you can provide the more detailed notice that we've discussed several times during this webinar, and that there's more information about in our guide on our website. But otherwise, the type of notice telling a tenant that they must pay it, just generally, you can't do that unless it includes all that other information, and including that you can't evict them for it if they don't until after September 30th. Can you elaborate on other options for pursuing collecting unpaid rent during the emergency period? So again, this is an area that's probably getting a little bit beyond my expertise. Although I do know that, really, if you think about landlord-tenant law, there's really sort of two separate things. There's the notice and eviction process that's laid out in the landlord-tenant statutes, and that's mostly what we've been talking about. And the eviction ban we're talking about really only relates to notices of non-payment related to terminating the tenancy and evicting a tenant. But a tenant still owes you the money, and so you can pursue other civil remedies. You can, sue for breach of contract, or other actions to collect money that's owed to you. But under these laws, you can't issue any notices or pursue any actions related to termination of the tenancy or eviction of the tenant. So that's sort of a legal answer. And then related to other options in terms of sort of strategies that landlords employ, I think looking to one of the landlord-focused trade groups like Multifamily Northwest is probably the best place to find more information about strategies. Certainly, a lot of landlords are working to engage with their tenants in optional payment plans. Reducing, temporarily reducing the amount owed each month, not reducing the overall amount owed, but coming up with some sort of payment plan that works better for the tenant's current financial situation. And so that's certainly something that landlords can pursue. And I know in some instances that's working very well for landlords. In other instances, there are tenants that don't want to do that, and that know that they can just not pay until these emergency periods and grace periods are over. But I would encourage you to reach out to a group like Multifamily Northwest, and I think they even have forms that they've created related to a voluntary agreement that you can enter with your tenant to come up with a payment plan that works for both parties. So take a look at that. Question: what would you say to a landlord investor client who insists that it is realtors or brokerage's responsibility to know, advise on landlord tenant law, either based on a realtor's professional knowledge, experience, or on brokerage hiring an attorney to provide such advice? This client has a property manager, by the way. What are reasonable expectations of a property manager where landlord tenant law is concerned? Well, I think the issue here is that it's really it's the buyer and the seller that are going to be the ones on the hook. They're the landlord, and so the seller's the landlord now, and the buyer is going to become the landlord when they take over the property if the tenant is still there. And so because the burdens of the law and the potential costs and damages and violations really are going to accrue to those parties, I think that's really why it's so important for them to be the ones seeking their own representation. Now, realtors and property managers should also be aware of the law. I mean, property managers should certainly be well aware of the law and ensure they're following it, because that's what they need to do on a day-to-day basis. And realtors should be aware of the general legal frameworks, and that's why we're putting on this type of event and producing guides and things like that. But when you get down into the weeds of the particular circumstances of the buyer and seller and all of the potential pitfalls and traps that exist with not only Senate Bill 608, but now several layers of eviction moratoria layered on top of that, it's just a level of detail that's beyond what should be expected of a realtor to know. And a realtor really would be entering dangerous territory if they were trying to advise their clients at that level of detail. Okay, what if an owner wants to evict the tenants to place the home for sale? So yeah, so we talked about if the home is going to be sold to a person who is moving in as a primary residence, then if it's after the first year of tenancy, the owner can issue a 90-day notice pursuant to the other requirements of Senate Bill 608. There was an earlier slide that went through that. So if you issue a 90-day notice, and if you own more than four, if the owner owns more than 4 rental dwelling units, then they also would need to pay a relocation fee. If they own 4 or fewer, they do not. Then that 90-day notice will be effective. Now, sort of hiccup in all of this is, what about in the first year? So prior to this eviction moratorium, if it was the first year of the tenancy, the owner could evict for no cause with a 30-day notice, regardless of the reason. So it could be because they're selling to a person moving in as primary residence, could be for any other reason. But now this eviction moratorium bans the no cause eviction. So if it's after the first year, we have this landlord-based reason, the 90-day notice, if you're selling to a person moving in as a primary residence. But if you're in the first year, you don't have a solution. So in that case, the landlord would have to wait until either that 30-day window that they get to do the no cause eviction, if they crossed over the 1-year mark during the tenancy, or once the tenancy moves into after the first year, then they can pursue the 90-day notice. The advantage of using that 30-day window, if that situation applied to the owner, if they did cross over the 1-year mark during the emergency period, then they could do a 30-day notice. But back to the question, that's really the only reason after the first year that you can evict for placing the home for sale is for sale to a primary residence. So if the intent is to evict for another reason and the buyer isn't moving in as a primary resident, then the simple sale of a home is not a reason to evict. It has to be to a person who is going to move in as a primary residence if it's after the first year, or you do the no cause in the first year by using that 30-day window that you get, or you wait until after the first year and do the 90-day. Can rents still be raised during the time frame? Yeah, rents can be raised, but only according to the laws that are in place under Senate Bill 608, which limited rent increases. Is a landlord allowed to sell rental property to another investor landlord if he or she agrees to honor a rental agreement after sale closes? Yes. So if the tenant's staying in the property, then none of this really, if you're not trying to evict the tenant, then you don't have to worry about when you can and cannot pursue eviction. Now, the old owner of this property and the new owner, the investor, who's buying it, they of course are going to be subject to these moratorium, and the fact that tenants may not pay their rent during the emergency period and may not pay that rent back until March 31st. So the investor who's purchasing the property needs to understand all of these laws that are in place and make sure that they're comfortable with that. But certainly a transaction that's simply changing ownership of a property, but the tenant remains in the home, that is certainly allowed. From YouTube, what if a tenant doesn't pay the full 6 months? What is the landlord's ability to pay for the full 6 months? What is the landlord's ability to recover the lost rents if a tenant vacates the property and doesn't pay? So as I mentioned before, the tenant has a legal obligation to pay the landlord. And while there are limitations in place based on these moratoria related to the ability to issue notices of termination and to evict for that non-payment, does not change the fact that the tenant still owes you the money. So you can pursue a civil action to recover that money from the tenant. And if you want to do that, you can consult with an attorney who can talk to you about the process related to doing that. But you can definitely go after the tenant in court to pay you the money that they owe you. How soon will this be in YouTube? Want to re-listen soon? I don't know. Katie would know that. So if she wants to answer that one.
It will be in the next two to 3 days.
Great, thanks, Erica.
You're welcome.
Okay, so if you have tenants and the house has tenants, so if you have tenants and the house has tenants and the buyer is going to live there, if they're getting a mortgage, the buyer needs to move in 60 days, but we have 90 days notice. This seems to be a huge stop to any sales. Sorry if this is confusing. Yes. This is not related to the current eviction ban. This is a problem with Senate Bill 608 that passed in 2019. This is a problem with that bill generally. And we agree that this is a problem. This 90-day notice required for a sale of a home to a person who's moving in as an owner occupant of the home. Because that 90 days does not line up with the time frame that some loan products require that you move into the home as a primary resident. So if there's ever a chance to amend Senate Bill 608 in the future, this is our top priority for an amendment to that bill. We don't know if and when that opportunity will come, but the OAR Government Affairs team has this as a top priority if and when it's a possibility to try to make that change to the law. Okay, send the letters after the emergency period ends. Okay, so back to the letters. There's two types of letters. There's one you can send during the emergency period, and there's one you can send after the emergency period. The one you can send during the emergency period can say basically, hey, you haven't been paying me the rent, you still owe me the rent, but I can't pursue eviction until after September 30th. Okay. Again, in the documents that we put online, we have some more information on that, and you can also link to the bill where it says exactly what you're supposed to say, but that's the gist of it. So that's a simpler notice. And then after the emergency period, you can send a notice that provides a lot more detail, and it tells them not only that they still owe you the rent that they haven't paid you during the emergency period, it tells them that there's a grace period that they need to tell you if they want to use until March 31st, and sort of puts the onus on them to tell you about that, or else they could be liable for some damages. In that letter, it also is your opportunity, and in fact, you must say in that letter that rents and other fees and charges that come due after September 30th, after the grace period ends, or after the emergency period ends, if those are not paid, then the landlord can evict for that reason. So that's the opportunity to let them know that. And several other items that need to be in that letter. So there's a simple letter during the emergency period that says, hey, you still owe me the rent during this emergency period at some point, but I can't evict you till after September 30. And then there's a notice after September 30th that lays out a lot more detail about the grace period, about the fact that the emergency period is now over, and that if they're not paying you full rent for the future months, that you can evict them, and all of that. And as I mentioned, there will likely be forms available that lay out these notices so that it should be really easy for you to provide them. And I would really encourage you to use a pre-approved notice that a group like Multifamily Northwest puts out, which I'm sure they're going to be working on. This longer notice won't be relevant until after September 30th. So there's some time for Multifamily Northwest and other groups to put something like that together. This more short form notice during the emergency period, I've heard that Multifamily Northwest is already working on some language related to that they're gonna post. As I mentioned, if other groups are not producing these, we'll take a look and see what we can do to help there. Question: during this time, can a landlord increase the fees for a co-occupant in the home? I'm aware of a lease agreement in a retirement community where the landlord is more than doubling the co-occupant fees from current $75 a month to almost $300 a month with the lease renewal language. I don't know a lot about co-occupant situation, so I think I'm going to pass on that one because I don't think I'd provide a very satisfactory answer to your question. But if we come across information that helps inform the answer to that question, we'll certainly post that. How is investor buying rental property held to honoring rental agreement when tenants who have occupied for over 1 year? So an investor a person who buys a property automatically becomes the landlord when they take over that property. Any leases or anything else that property is subject to are now going to be the responsibility of that the new owner. But really, all of that should be spelled out. Anyone getting into the business right now of purchasing or selling a rental property should make sure that all the details are understood by both the seller and the buyer, and that everybody understands what their burdens are going to be, including and especially the new owner who's taking over the tenancy. So that's why I think it's very important for both parties to seek legal advice. But generally speaking, if you buy a property and there's a tenant in the property, and the new owner is the landlord and is subject to the rental agreement. Okay. All right. If the eviction process is already in process before April 1st, but it was not done, what happens during the grace period? So if the eviction process was already in place before April 1, then that means that whatever you were evicting for was not protected under the emergency period. So that could proceed without any intervention of this bill. However, as I mentioned before, the courts are doing very limited operations, and the question is going to be whether is the court processing these, and how backlogged are they, and how quickly are they getting through them. So that's something that you should check with the clerk of your county court. But if the issues that led to the eviction occurred before April 1st, then there shouldn't be there's not a reason in this bill that you cannot pursue that. Okay, where was that it? Or somehow I got back to the top, so I don't think that was it. But let's see. Sorry, I'm just getting back to where we were here. Hey, Katie or Eric, if either of you, oh, here we go. I found it. Okay. What is the current status of asking tenants to allow showings of rented homes that are for sale? So there is no law directly on point to this issue. Obviously, it's a very sensitive issue because of COVID-19. So there's no law in place. There was some discussion. I know that some tenant activists were trying to get something about this issue into this bill that just passed, but it did not get in there. So I think what you're operating under here is best practices around trying to protect people from COVID-19. And so, under your rental agreement and under the statutes of the state, well, likely under your rental agreement, I haven't seen your rental agreement, but there is a right for a tenant, for a landlord to enter the property with appropriate notice, and the landlord can show the property. But the tenant also has the ability to refuse if they believe that request is unreasonable. And with the whole COVID situation, there may be some tenants who feel like it's unreasonable to have people enter the home. So what we suggest in our guidance that we put out is to just work with your tenants to come up with a mutually agreeable protocol for people, the number of people that are going to come through the home, people wearing masks and sanitizing things and not touching things, and just come up with a really good protocol and try to come to a mutual agreement with your tenant about the showings. We do have guidance posted on this on our website, I think in the buyer and seller advisories, as well as in some of our guidance around how to operate during phase 2 and general guidance for brokerages and real estate activity. Like I said, the landlord likely has a right under the rental agreement and generally has a right under the statute, but these are unusual times. And so it may be that more tenants would object now than in the past. And, I think try to come up with a mutually agreed upon protocol. And if the tenant still refuses and they're claiming concerns about COVID-19, you really don't want to be forcing yourself in. And so you may end up having to go to court to try to resolve that, go to the landlord tenant court to try to resolve that issue. Can we raise rents during the emergency period? Yeah, you can raise rents, but only according to the laws in place under Senate Bill 608. This bill does not address raising rent. Question: if a landlord sent a notice of non-rent payment mid-June and said they would start an eviction process by July, if no communication was given, and this was before the latest extension, can that be used against a landlord? As in, could a tenant say the landlord violated the law? Okay. No, there's a lot of concerns about this bill. A lot of people are saying, this is sort of an ex post facto law, a law that's trying to govern behavior prior to when the law was passed, which is generally not allowed and is unconstitutional. So the way I would see this is that if you sent a notice that was not prohibited by law when you sent it, then you were not breaking the law. Does that stop a tenant from reading the law as it currently exists now and saying, hey, you did this during the emergency period and you weren't supposed to? The tenant can make that argument, but I think the landlord has a very strong argument to say that they were operating under the law as it existed at the time. And obviously you could not have predicted what would be in this law, so you're not subject to its provisions. And it'd be interesting. I wouldn't be surprised if there's some lawsuits that arise out of this legislation related to issues of ex post facto laws, of contract clause, of takings, and other issues. So we'll see what happens. Okay. Currently, most of our tenants pay their own water and electricity, but there are landlord agreements in place that if the tenant doesn't pay the water company, water stays on, but the bill goes to the owner. can we remove this landlord agreement and still consider the home habitable? In other words, can we let the tenant suffer no water or power because they are not paying the providers as written in the rental agreement? Yeah, you're not going to want to do anything to retaliate against a tenant for exercising their rights that they now have under this law. So you should not be doing anything to retaliate or to interfere with the tenant's use of the property, because they have the right to it under this law. Do I understand correctly that the tenant can still be evicted during the emergency period for property damage? Yeah, so the emergency period is related to non-payment of rent. All the laws that already exist related to reasons you can evict a tenant for tenant-caused issues, including damage to property, violence, drug and alcohol violations, unpermitted pets, other issues. All of those laws are still in place. In the guide that we put out, we put a list of the statutes that lay out the tenant causes for eviction and link to them. And so you can take a look at that and see all of the existing reasons why you can evict a tenant. Nothing in this law changes that if it's a tenant cause. And that's true during the emergency period and after the emergency period. Question, can we include the language, please take into consideration that non-payment of rent does impact our ability to fund repairs and maintenance of the property? My advice would be to stick with exactly what the language in the statute lays out related to what should be in these notices. I'm not sure I have a definitive answer to your question, but my initial answer would be that folks should stick with precisely what is in the is laid out in the statute. But that's a question that you might want to look into a little bit more. But I would stick with what's in the statute. If my buyer purchases a duplex and occupies a vacant side and accepts a month-to-month renter on the side, when can the buyer raise the rent on month-to-month renter? So again, this doesn't have anything to do with the current bill. This is related to Senate Bill 608. So I don't think I'll get into the details of that one. But we've put out several documents related to Senate Bill 608 and what it includes, and you can check that out. That bill, of course, restricts rent increases in the first year of tenancy and restricts annual rent increases. Let's see, good ending disclosure. Good ending disclosure. Okay, I'm not sure what that, whoever wrote that question, good ending disclosure, if there's a question in there, let me know and we'll try to answer it. What if an owner wants to evict the tenants to place the home for sale? So we've already talked about that. If it's after the first year, you can only do that if it's a person moving in as a primary resident and they have to give 90-day notice. If it's within the first year, you can do a no cause, but only if you qualify for that 30-day window, because otherwise the no cause eviction is not allowed during this emergency period. Okay, question. I served a 90-day notice of termination for a tenant for landlord reason number 1 on June 24th on a property under a sale contract. Will this be valid? So a 90-day notice of termination. Tenant. Well, I don't think the problem is the notice being valid. I mean, the notice, well, as I mentioned, the governor's ban was unclear on this. And I would say that a good number, probably majority of attorneys who've read it think that the governor's ban really applied to all evictions without cause, including all of the landlord-based reasons. So if that interpretation is correct, then the notice wasn't valid at the time you gave it. If that interpretation is not correct, then this bill, the notice would be fine because you issued it before the bill, but any additional steps related to the eviction of the tenant for that reason would not be allowed. So that's going to be the problem. And if the tenant were to leave voluntarily based on that notice, then you wouldn't have a problem. But if the tenant does not and you need to pursue eviction, you would not be able to do that until after the emergency period ends, after September 30. Okay, question. Seller has accepted offer. Tenant has been renting several years. Buyer's agent to do major remodel. Deferred maintenance and remodel. Home will not be habitable when completed. Immediate family member will move in. Can notice now be given to tenant. So I see several reasons in there. You know, the landlord reasons, the major remodel, immediate family moving in. But as I mentioned before, none of those reasons are valid reasons to terminate a tenancy under this bill. So until October 1 or later, you cannot evict the tenant or issue a notice of termination for those reasons, but you can after that. Is there any restriction on showing rented homes? What notice are required to give tenants? Yeah, we mentioned that earlier. There's nothing particular in the governor's guidance or in any of these laws that addresses this, but there are significant sensitivities related to COVID-19 and people's concern about their health. And so just be very cautious and try to come up with a protocol that keeps everyone safe and that works for your tenant. And then go from there. And as I mentioned before, landlords have the right to enter, but if that entry with appropriate notice, but if that entry is unreasonable, and the tenant says it's unreasonable, the tenant can object. And if you're in a situation where you and your tenant can't agree to allow the showing to happen, then you may have to end up in court to resolve that dispute. Here's a link to the guide again. Okay, so I think we got through it all. Erica, Katie, am I right that we're through all the questions?
You're right. We've hit them all.
Sweet. All right.
Yeah.
Well, thanks everyone. This was great. I'm glad that we were able to do this today, because today was the day that the governor's ban was ending, and it's when this new ban is beginning. And so this was very timely. I do want to remind everyone that what we did today was go through the general provisions of the law and try to answer your questions in a general form. Legal matters are very fact specific. And so there's way more detail involved in your situation, likely, to truly resolve that situation than what we were able to cover today. So I think it's very important for everyone to, if they have any doubt about what they're doing, they should contact an attorney to make sure that they are proceeding appropriately. And as realtors, while it's very important for you all to be aware of these laws generally, it's also very important for you to not try to play lawyer with your tenant, or excuse me, with your clients, and to tell them to consult their own legal counsel related to the sale or purchase of a property that has a tenant in the property. We'll continue to provide updates and updated guides on our website. In the chat feed, you'll see links at the top and the bottom to our guide on this bill. And if new interpretations develop based on this bill, and as more attorneys read it and discover things related to it, we will continually update our guidance. And thank you all very much for the time and the questions.
Yes, thank you everyone so much for attending. And Jeremy, thanks so much for all of your hard work on this. Just so you all know, here's some upcoming virtual courses that we've got here at OAR Education. It was wonderful having you here today. again, we'll be sending out an email to all registrants with the link to the recorded YouTube page once it's live, and we will include it in a newsletter coming at some point soon. All right, thank you, everyone.